Welcome to Docket Decoder. If you enjoy our content, please help us out by hitting that like button or leaving your comments for us. And don't forget to subscribe to stay up to date with the latest court filings. Order on defendant's motion to strike death penalty and adopt other necessary procedures. 1. Introduction. Defendant contends that the discovery produced by the state in this case has been voluminous and unorganized, thus rendering him unable to meaningfully review and investigate the state's evidence in time for trial. Asserting his due process rights have been violated, defendant seeks sanctions in the form of striking the death penalty and imposing certain organizational requirements upon the state to aid defendant's review of discovery. The state responds that it has complied with all discovery obligations, including Brady, and there is no basis for sanctions or other measures. Oral argument on the motion was held on April 9, 2025, after which the court took the matter under advisement. Because defendant has failed to show a discovery violation or due process violation by the state, sanctions are not warranted. The court further declines to require the state to provide further organizational assistance to defendant. 2. Standard. A trial court's decision regarding discovery violations must be supported by substantial and competent evidence in the record. Choice of sanctions for failure to comply with discovery obligations is discretionary. On discretionary matters, the trial court must 1. Correctly perceive the issue as one of discretion. 2. Act within the outer boundaries of its discretion. 3. Act consistently with the legal standards applicable to the specific choices available to it. And 4. Reach its decision by the exercise of reason. 3. Analysis. Pursuant to Brady v. Maryland, a prosecutor has a constitutional duty to disclose favorable evidence to the accused where such evidence is material either to guilt or to punishment. This duty covers not only exculpatory material, but also information that can be used to impeach a key government witness. Brady does not, however, grant broad discovery rights to a defendant. An interpretation of Brady to create a broad, constitutionally required right of discovery would entirely alter the character and balance of our present system of criminal justice. It simply imposes a due process standard upon prosecutors by requiring them to disclose favorable material evidence. In tandem with Brady, the Idaho criminal rules require the prosecuting attorney to disclose, as soon as practicable following the filing of charges, any evidence which tends to negate the guilt of the accused as to the offense charged, or which would tend to reduce the punishment. The discovery obligations under both Brady and ICR 16 extend to all the government agents having a significant role in investigating and prosecuting the offense. Defendant complains that the state has failed to satisfy its obligations under Brady and ICR 16 due to its method of discovery production. He contends that the state has turned over more than 68 terabytes of data in discovery consisting of in excess of 13,000 photographs, 15,000 video clips from businesses, and 8,000 video clips from residences. It also includes more than 60 digital devices, digital data, and search warrant return data. Defendant also contends the state has not provided the discovery in a searchable format and has not provided detailed logs of indexes that would facilitate defense's review of the material, and has not specifically identified any Brady evidence. Defendant argues he has been prejudiced by the state's data dump method of discovery and contends that sanctions are warranted in the form of striking the death penalty and excluding witnesses. He also asks the court require the state to identify Brady material or hot documents within its discovery. While the state acknowledges there is a massive amount of data in this case, it contends the majority is completely irrelevant. Specifically, the state contends that most of the data is from cell phone extractions and weeks of surveillance video footage throughout the Moscow area obtained following the homicides. It affirmed on the record that it is unaware of any Brady material in those videos other than those specifically identified in motion practice and otherwise throughout the case. Further, the state's experts who reviewed the various devices, including cell phones, and other digital data have disclosed opinions that they found no connection between the defendant and the victims from the devices and data. The state also notes that since this case began over 2 years ago, it has continuously turned over to defendant all the information it received from the various investigating agencies in the same format as the information was received by the state. This was done at defendant's request, who specifically asked that the state produce everything the state had from the get-go. Defendant also issued 400 itemized requests for discovery in this case. Thus, the state contends it is on the same playing field as defendant regarding discovery. In addition, the state points out that on September 4, 2024, at approximately the same time as its discovery deadline, it provided defendant with a 320-page index identifying the location of requested discovery, a description of the evidence, and the date discovered. In addition, all of the evidence received from the FBI, which comprises the majority, was provided to defendant with a searchable index. In sum, the state asserts it has provided everything required by ICR 16A and Brady, and disputes that it has engaged in any discovery violations. A. Defendant has not established a discovery violation, thus, sanctions are not warranted. There are three components of a true Brady violation. The evidence at issue must be favorable to the accused, either because it is exculpatory or because it is impeaching. That evidence must have been suppressed by the state, either willfully or inadvertently, and prejudice must have ensued. Defendant, as he appears to have acknowledged at the hearing, cannot establish these elements because he has not identified any withheld evidence that is exculpatory or impeaching. Further, he has not identified any obligation under ICR 16 that the state has violated. His quibble, rather, is with the method in which the state has produced discovery, arguing it is effectively a data dump that prevents him from meaningfully review the discovery for Brady material. There are, however, several problems with defendant's position. First, while neither Brady nor ICR 16 prescribe the form discovery must take, it is well settled under federal law that there is no direct obligation for the government to identify or itemize Brady material for the defense. While the Supreme Court in Brady held that the government may not properly conceal exculpatory evidence from a defendant, it does not place any burden upon the government to conduct a defendant's investigation or assist in the presentation of the defendant's case. Further, voluminous discovery alone is not a basis for finding concealment under Brady. This occurs typically in open file discovery, where the government effectively makes its entire file available to a criminal defendant. This method of discovery, which defendant requested of the state in this case, carries the recognized benefit of increasing the efficiency and fairness of the criminal process. It is only when the government uses the open file policy to hide exculpatory material or otherwise prevent a defendant's access to such material that a Brady violation will be found. For example, in United States v. Skilling, the Fifth Circuit observed that while the use of voluminous open file does not alone violate Brady, its misuse by the government can give rise to a Brady violation, stating, for instance, evidence that the government padded an open file with pointless or superfluous information to frustrate a defendant's review of the file might raise serious Brady issues. Creating a voluminous file that is unduly onerous to access might raise similar concerns. And it should go without saying that the government may not hide Brady material of which it is actually aware in a huge open file in the hope that the defendant will never find it. These scenarios would indicate that the government was acting in bad faith in performing its obligations under Brady. However, where there is no proof that the government larded its production with entirely irrelevant documents or made access to documents unduly onerous, a Brady violation will not be found. Here, the defendant has not shown any bad faith by the state with regard to discovery production. While the discovery is indeed voluminous, the court does not find that the manner in which the state produced it violates Brady or otherwise constitutes misconduct. The discovery was produced to defendant as he specifically requested. The state received the information from its investigating agencies, labeled the material, and turned them over to defendant through a shared access drive in the same format as received. This method not only puts the state and defendant on equal footing regarding discovery review, it also serves the important purpose of protecting against claims of missing or manipulated documents if the state puts them in a different format or organization or otherwise conveys them to defendant in a different manner than received. While the state acknowledges that much of the discovery is completely irrelevant, including surveillance videos and data from the numerous phones, computers, and other devices, it did not produce it for the purposes of padding the file or otherwise attempting, in bad faith, to hide Brady information in its haystack of information. Rather, defendant asked for everything, and everything is what he received. Defendant cannot demand everything under the sun and then complain about the weight of all the planets. Moreover, defendant has not produced any evidence showing the state has hidden Brady material or made his access to discovery unduly onerous. Although the state did not provide all of the discovery in a searchable format, as it was not received by the state in such a format, it provided a 320-page index identifying the specific location of evidence produced in response to defendant's 400 individual discovery requests, a description of the evidence, and the date discovered. In addition, the discovery received from the FBI, which comprised the majority, was provided to defendant in a searchable format. Other than the cell phone and digital data and video surveillance footage, defendant has not identified what information his counsel will be unable to review prior to trial, and why that information is material. Further, the state has stipulated that it is unaware of any Brady material in the video surveillance footage, other than that specifically identified in motion practice, and its experts who have reviewed all of the cell phone and other digital data in the case have opined they found no connection linking defendant to the devices and data analyzed. In addition, defendant's complaints of being unable to meaningfully review the discovery ring hollow. Defendant has been receiving discovery in the same manner for over 2 years. In that time, he has not once sought a remedy from this court to regulate discovery, such as requiring the state to provide discovery in a different format. He has not sought additional resources under ICR 12.2 to hire additional staff to review discovery or obtain litigation document control software to help organize and sort the evidence. His lead counsel insisted that she be allowed to take on a second high-profile capital case, despite the voluminous discovery in this case. Further, at oral argument, lead counsel indicated that her practice is to personally review all of the discovery herself, rather than rely on associates and staff to review materials to cut through the less relevant information and point to what materials need review by lead counsel. These actions are not indicative of an overburdened defense team. In fact, it is evident defendant has been able to capably navigate the discovery given his more than robust motion practice, the scope and breadth of the experts retained, and the disclosures filed. In the cases cited by defendant where the courts have struck the death penalty as a sentencing option, the defendant has demonstrated that the prosecution either willfully or inadvertently, but with extreme resulting prejudice, violated discovery obligations. Here, however, defendant has not established a discovery violation under Brady or ICR 16 in the first place. He has not shown the state has attempted to conceal specific materials within the discovery, and he has not shown discovery to be unduly burdensome to the point where he is unable to examine the items that are material and of evidentiary value. Consequently, there is no basis for any sanction, let alone striking the death penalty. B. The court declines to impose organizational requirements on the state. Defendant additionally asks the court to require the state to identify Brady material or hot documents within its discovery. The court finds neither is warranted. While the general rule is that the government need not specifically identify Brady material within a larger mass of disclosed evidence, courts will sometimes order the government to organize voluminous discovery to comply with the spirit of its statutory and constitutional obligations. Such organizational measures include requiring the government specifically designate any known Brady material within the discovery. Whether to order such identification is highly dependent on the facts and circumstances of the case. Courts consider not only the volume of discovery and how it was produced, but the relative position of the defendant requesting identification, such as 1. A defendant's access to counsel, 2. Whether the defendant is incarcerated, 3. A defendant's access to resources, 4. A defendant's ability to participate in the preparation of his own defense, and 5. Whether the interests of multiple defendants are aligned. In Safarinia, for example, the government produced approximately 1 million records and 3.5 million pages of documents in discovery. With this discovery, the government provided production logs, bait stamping, and metadata in electronic and searchable format. The court found that under the circumstances, the government's Brady obligations required it to identify any known Brady material to the extent that the government knows of any such material in its production. In doing so, the court emphasized that the defendant was an individual defendant who neither had the benefit of parallel civil litigation nor access to voluntary corporate assistance to sift through the massive amounts of documents within the government's voluminous production, that the defendant's counsel was handling the case pro bono with time constraints and limited financial resources, and that the government, assisted by at least two federal prosecutors and several federal agents from at least two law enforcement agencies, had the luxury of reviewing this material on a rolling basis over the course of its 3-year investigation. Likewise, in Salyer, the court directed the government to identify previously disclosed Brady Giglio material to the defendant where the government collected documentary information during a 5-year investigation, and the government's massive production consisted of electronic information with multiple gigabytes and millions of pages. The court reached that conclusion based on the circumstances of that case, which included 1. There was a singular individual defendant who was detained in jail pending trial and who was represented by a relatively small defense team, and 2. There was no parallel civil litigation and the defendant did not have access to the voluntary corporate assistance in attempting to find the documents needed by the defense. By contrast, in United States v. Meek, the court declined to compel the government to identify Brady material in its discovery, noting that 1. The government produced the discovery in a user-friendly, searchable, and indexed format. 2. There was no indication that the government deliberately concealed or buried any exculpatory evidence in the information it turned over to the defense. 3. The defendants were sophisticated, formerly high-level executives represented by experienced and talented counsel from notable law firms. And 4. The defendants had access to the discovery for over a year and had it in the same format as did the government. The court further pointed out that ordering the government to identify or label already produced material as covered by Brady, and by omission identifying non-Brady material, only invites future disputes as to whether the government did an adequate job of identifying such material or characterized the material consistent with the defendant's view of it. While defendant is currently incarcerated, he has a robust defense team and has not faced time constraints given his speedy trial waiver, with this case well over 2 years old. Further, unlike in Serafina and Salyer, defendant has had nearly as much time as the state to review discovery. Defendant was arrested on December 30th, 2022, approximately 6 weeks after the homicides. Defense counsel filed a notice of appearance on January 12th, 2023, and the state first began providing discovery on January 18th, 2023. Thus, this is not a situation where the state has had the benefit of years-long investigation compared to a defendant who has had mere months to review the investigative material. Further, the court shares the significant concern voiced in Meek that requiring the state to identify Brady material in already produced discovery, or to organize it in a way different from how the state received it, would simply invite future litigation as to whether the state did a sufficient job. Not infrequently, what constitutes Brady material is fairly debatable, where the circumstances do not, as here, cry out for departure from the general rule. The court will not invite such future disputes. In addition, there is no need to require the state to disclose a list of hot documents, which is a tool imposed by some courts for particularly voluminous discovery to aid the defendant in identifying material that deserves closer attention. The state has effectively already done so. Defendant was indicted by a grand jury. This process required the state to present evidence supporting the elements of the charges and identify any substantial evidence which directly negates the guilty of the subject of the investigation. Defendant is privy to all the evidence produced by the state at the grand jury proceedings in this matter. Further, the state recently disclosed its exhibit and witness list identifying precisely what the state intends to use to support its case. Additionally, the state has taken reasonable steps to aid defendant in navigating the discovery, including by 1. Providing a detailed index of all the discovery produced, identifying the location, a description of the evidence, and the date discovered. 2. Providing the FBI materials with a searchable index. 3. Working with counsel to resolve access problems to documents. And 4, representing that the surveillance videos other than those highlighted by the state do not contain any relevant footage, and that the devices, phones, and other digital data of the victims and others do not show any connection between the defendant and the victims. Collectively, this provides the defendant reasonable means to meaningfully review the discovery he requested. Consequently, the court declines to impose additional organizational requirements. 5. Order. Based on the foregoing, defendant's motion to strike the death penalty and adopt other necessary procedures due to the state's disclosure violations is denied. It is so ordered. Dated this 29th day of April, 2025. Stephen Hippler, District Judge.